A federal high court in Abuja has ordered the Department of State Services to grant Nnamdi Kanu access to his doctors of choice and his medical records. Justice Binta Nyako, who delivered the judgment on Thursday, said objections by the DSS against Kanu lacked merit, adding that he was constitutionally entitled to access both his medical records and his doctors. In a suit marked FHC/ABJ/CS/2341/2022, filed by his team of lawyers led by Professor Ozekhome, SAN, Kanu had applied for an order of mandamus compelling the security agency to allow him access to his private physicians to conduct an independent examination to determine his actual state of health. He prayed the court for an order of court granting leave to the applicant to apply for judicial review in the form of an order of mandamus, compelling the respondent to avail the applicant of all his medical records from the 29th day of June 2021 till date, which Justice Nyako had earlier ordered on October 21, 2021. According to Chief Ozekhome, SAN, the respondents have repeatedly denied the applicant access to medical doctors of his choice to independently examine him, contrary to the order of the court made on October 21, 2021, and the express provisions of Section 7 of the Anti-Torture Act 2017. Some of the medical records requested include admission records, medical and clinical notes, nursing notes, observation charts and documentation during treatment or stay in hospital, laboratory test results, pharmaceutical records, radiological scans, images and reports, blood transfusion records, physiotherapy and rehabilitative treatment records, clinical findings, as well as diagnosis and treatment prescribed records. Justice Nyako in her judgment therefore held that the DSS should not interfere with Kanu's rights to gain access to his medical records. The court also held that his team of medical doctors would supervise the requested medical examination of Kanu outside the facility of the DSS, and that the reports should be sealed for security purposes. On the whole, the application succeeds and is hereby granted, Justice Nyako held, having dismissed objections by the counsel for the DSS, A.M. Danlami, challenging the jurisdiction of the court to grant the request. Reacting to the judgment, lead counsel for Kanu, Ozekhome, commended Justice Nyako's courage and godliness in her judgment, adding that the earlier judgment of the court, striking out 8 counts and the stricken 7 counts by the appeal court, had now become a case study in the legal practice.
Today, this court, the Honorable Justice Binta Nyako, granted all the reliefs sought for by Mazi Nnamdi Kanu before the court. The young Nigerian patriot, Igbo self-determination czar, who was extraordinarily, illegally, unconstitutionally, torturously, brutally renditioned from Kenya back to Nigeria on the 27th of June, 2021. Today, the court agreed with us that the reliefs we asked for must be granted, and the judge granted. What were these reliefs? That Nnamdi Kanu be allowed access to medical doctors of his own choice, as earlier also ruled by this honorable court since October 2021, but which ruling was continuously, serially and contumaciously breached by the SSS. Today, the court ruled that he was entitled to have access to his medical practitioners of his own choice, and that these medical practitioners should be present whenever any examination or procedure is to be done on Mazi Nnamdi Kanu outside the facilities of the SSS.